So I think it's probably a good place to start. A good place to start is that we sort of categorize our benefit system. So that every benefit would sort of fall under a different heading. So some of these terms may be familiar to some of you. So we have means tested benefits. So things like universal credit, which are assessed based on your income, savings, that sort of thing. We have non-means tested benefits. So that would be things like disability living allowance, personal independence payment, those sort of things that are based on, say, a health condition or a disability rather than sort of your means and whether you're working or not. We have contributory based benefits, which entitlement is based on your national insurance records being up to date, or national insurance that you've paid in work. Probably the most famous would be the state retirement pension. And then the last one that we could probably categorize would be local support. So that would be things like discretionary housing payments and council tax support that is administered by the local authority. But yeah, let's look first of all at disability living allowance. So we'll look at these questions. So what is disability living allowance? And the equivalent, we'll touch briefly on how that looks in Scotland, just slightly different. How to apply for it, what an entitlement of disability living allowance can sort of also entitle you to. And as Vicky says, we'll have a look at carers allowance as well, and we'll touch briefly on PIP and how to challenge decisions. So disability living allowance. So disability living allowance is a disability-based benefit that a child can claim between the ages of 0 and 16 on the basis that they require more care and attention than a equivalent child without the sort of health conditions or disabilities that they have. So there are two components to disability living allowance. So there's the care component, which really looks at the sort of practical care that is needed on a daily basis. And this can be sort of categorized into 3 levels dependent on need. So the lower rate, so this is the sort of legal sort of definition of each one of these. So the lower rate of £29.20 a week, if one requires some spells of care and attention during the day or night. So if there's sort of a few periods that that's required, then that may qualify you for the lower rate. The middle rate of £73.90, if one requires frequent attention, supervision during the day and or at night. And the higher rate of £108.55. Sorry, that should be £110.40. Sorry, my error. If one requires frequent attention or supervision during the day and night. So as we can see, the more sort of care and support somebody would need during the day or night would determine the rate that somebody may be entitled to in terms of the care component of DLA. So the mobility component, there are 2 rates. The lower rate of £29.20 a week. The lower rate is really concerned with sort of guidance and supervision when mobilizing. So this is really looking at perhaps if there is a behavioral problem, for example, or a learning disability that would mean that there's a risk, for example, of a child running out in front of a car, and they would need to be supervised in order to sort of mitigate any damage occurring as a result of that. And the higher rate of £77.90 a week, this is the definition. If one is virtually unable to walk or significant risk of injury. So this is really looking at the physical side of mobility. So things perhaps like slower walking pace, breathlessness, fatigue, muscle aches, pains, that sort of thing. Whilst I said before the disability living allowance is available for any child from 0 to 16, the mobility component is a little bit more restrictive. So a child can only receive the higher rate for DLA once they hit the age of 3, and 5 for the lower rate. So the basic qualifying conditions for disability living allowance are these. First of all, living in England, Wales or Northern Ireland. In Scotland, it's slightly different. I don't know whether there's anybody from Scotland on the call this evening. But disability living allowance is part of the devolved benefit system in Scotland, referred to as child disability payment. It operates in exactly the same way, and it measures exactly the same sort of activities, and it's assessed the same way. But just to highlight that it would be a separate application to child disability payment as opposed to DLA. So yeah, the qualifying conditions are as follows. So as we said, age between 0 to 16. There's a consultation at the moment looking at increasing that to 18 from next year, and we'll just have to wait and see how that goes. We need to satisfy the past presence test. So depending on the age of the child claiming, they need to have been in the UK for a certain period of time. They need to have recourse to public funds, so don't have any sort of restrictions attached to their leave if they're not an EEA national or a UK citizen. Need to be habitually resident in the UK, so that's that they have a strong kind of link to the UK. Obviously have a disability or a health condition that means they have this higher sort of level need of care or supervision. I think it's really important to highlight at this point. Vicky mentioned one of the misconceptions with DLA is that there needs to be a diagnosis in place. That's not necessarily true with DLA. If a child has been experiencing sort of side effects for a period of 3 months before the date of a claim, there's nothing to stop a claim being assessed without having a defined health condition in place. So I think it's important to highlight that. And as we've said, must be experiencing the difficulties for 3 months before the date of the claim and for 6 months going forward. So the care component of DLA, the activities that it looks at include the following. So any difficulties that a child would have washing. So again, the washing, dressing, eating, using the toilet, communicating. So as I've mentioned here, examples of these could fall into sort of physical restrictions or perhaps non-physical restrictions. So it could be like things like pain, breathlessness, high levels of fatigue, cognitive impairments that really mean that they require that level of supervision and attention compared to a peer of an equivalent age. So this is just an example, a sort of skeleton answer that I put together in terms of a child that may have difficulties with eating and drinking. So this is an example of where supervision and attention may be required. So in respect of eating, due to high levels of fatigue, lack of motivation, cognitive impairment, or memory loss, this is an activity that child can struggle with, finds that he can go for long periods of time without eating, affecting his nutritional and all-round well-being. Therefore, in order to make sure that that doesn't happen and there's no further decline in his health, he would need prompting, reminding, and physical supervision kind of on a daily basis to make sure that that he's able to sort of get the nutrition that he needs and stop any sort of deterioration of his health. And hopefully, if that's kind of plausible, that would be acceptable for that that activity. So moving on to the mobility component. So we've discussed for the lower rate, it would be assessed on what's called guidance and supervision. So yeah, if a child has a disability or a health condition, meaning that there is a risk of injury occurring with regards to developmental delays, severe behavioural problems, may be able to qualify on that. And in terms of the higher rate, as we've mentioned, factors such as slow walking pace, breathlessness, pain are all factors that could satisfy the unable to walk. So unable to walk would really mean if one is unable to walk, kind of, again, equivalent to someone that doesn't have the health conditions. So a child of an equivalent age. So here is an example there are some circumstances where a child may have a developmental or behavioural health condition that may result in being entitled to the higher rate. And this is an example where it may occur. I'm not going to go into sort of the legal stuff, but just to sort of summarise how entitlement may be satisfied. So due to autism and disinhibited behaviors when mobilizing, child can be impulsive, running out of moving cars and needing physical restraint. If it reaches a certain sort of threshold, there may very well be an entitlement to the high rate, but it would need to be quite a high threshold. So how to apply for disability living allowance? Forms are available on the DLA website there. Similarly in Scotland, if you were to just have a quick Google of child disability payment, forms easily downloadable, can complete it online or run it off, complete it by hand. And then there's there'll be a number on the child disability payment to request a form as well. Child DLA forms can be requested on the number there. In terms of how a claim is assessed, if you were to download a form and complete it yourself and return it, any sort of decision to pay would only be awarded from the date that that form is received, whether as in comparison to if you were to phone and request a form, the date in which it could be payable would be that date. So it may be sort of prudent to sort of call up and request a form just to make sure that there's no sort of loss of any entitlement. So any changes of circumstances that may have a material difference on a claim. So if there is a change in the care needs or the mobility needs, once a claim is in payment, perhaps a child's care needs have got worse or even got better, those can be reported on the same number there, on the 0800 number. And under current regulations, once a child reaches 16, DLA will stop and they will be required to make a claim for personal independence payment in England, Northern Ireland and Wales, and adult disability payments in Scotland. And even once that happens, DLA payment would continue to run whilst the claim for PIP is being assessed. So it won't, providing that the claim is made within the allocated time frame, the DLA will continue until that PIP claim is assessed. So once a decision is made, letter will be sent out with the decision. So DLA claims are roughly taking 26 weeks at the moment. There's quite a big backlog. So if you were to make a claim and you didn't hear anything for quite a prolonged period of time, it's very normal. You can receive any sort of combination of the components that we've mentioned. So you could receive care and mobility, care or mobility, or nil entitlement. If awarded, it will generally be for a set period of time, typically 3 to 4 years, but maybe longer in certain circumstances. And at the end of that period, you will need to reapply if still eligible and haven't reached the age for PIP or anything like that. And if you're not happy with the decision, normal appeal rights will apply. And we'll look at those a little bit later on. So if a DLA claim or even a PIP claim was to be awarded, these are sort of other entitlements that may sort of arise as a result. So if somebody is awarded, if a child is awarded DLA at least the middle rate for the care component, there may be an eligibility for carers allowance for a parent if they're eligible for that. There may be an increase in certain other means tested benefits, so disabled child elements in universal credit or potentially carer elements and that sort of thing. If they are awarded the enhanced rate for mobility, there may well be an automatic entitlement to a blue badge, which may be helpful, as well as other sort of bus passes, road exemption, road tax exemptions, mobility vehicles, and also potential exemption from the benefit cap on the basis of having a disabled child in the household. So we'll touch now really briefly on personal independence payment. Again, this applies to England, Wales, Northern Ireland, and in Scotland, adult disability payment. It's the same premise really. Operates in exactly the same way, is assessed in exactly the same way. Just as part of devolution, it's just been renamed. So personal independence payment is the main disability benefit for working age people over 16 up until pension age. So as we've mentioned before, once a child reaches 16, they will be invited to claim personal independence payment. It won't be an automatic sort of transition over onto PIP. They'll need to make the claim. If the claim is made within the time frame permitted, the DLA will continue until the PIP claim is sort of assessed. And in some ways, it's very similar to DLA. It looks at the difficulties that one sort of has with their daily living needs, which is similar to the care needs and mobility needs. It's looking at whether somebody can complete the activity to an acceptable standard reasonably and safely in a decent length of time. So any sort of restrictions that may arise, that means there's a risk to someone's safety, or they need to be prompted, reminded, encouraged, need to take breaks. There are all sort of factors that could be significant in getting a claim for PIP. So similarly, with DLA, there are two rates. As we've mentioned, there's the daily living rate, which is assessed at two rates, £73.90 for the standard rate and £110.40 for the enhanced. And similarly with the mobility, there's the standard rate of £29.20 and £77.90 for the enhanced rate. And as with DLA, you can receive all sort of mixture of components. So as some of you are probably aware, PIP is awarded on a points-based basis. So in order to get an award for the standard rate for the daily living rate or the mobility rate, you need to score a minimum of 8 points and 12 points for the enhanced rate. So these are the activities that PIP looks at in respect of the daily living component. So any difficulties that you would have or someone would have preparing food, eating and drinking, remembering to take medications, toileting needs, getting dressed, getting washed, any difficulties with communicating, reading, managing money, and mixing with other people. And in terms of the mobility, it looks at any difficulties that one would have going out. So, for example, if someone was too anxious to leave the house and would need support, or due to a cognitive difficulty, they would have restrictions in following a familiar route or a new route and would need assistance with that. That's what that particular activity looks at. And then the other sort of activity is the physical walking sort of activity. So whether there's any difficulties with the physical aspects of walking. So again, things like breathlessness, slower walking pace, needing to take regular breaks, balance issues, that sort of thing. So how to claim PIP? The sort of basis to do that is to telephone the new claims line. The number is there, and the number will be available on the Adult Disability Payment website for Scotland. After making that initial call, which will last about 10 minutes, which just captures basic information, name, address, national insurance number, etc., a medical questionnaire would be issued to complete, giving really the opportunity to express the sort of difficulties that you're having with each of those activities, and to supply supporting medical evidence. Generally have 1 month to return the form to PIP, and really important to supply any medical evidence where possible. So once the form has been returned, it's highly likely that an assessment would be required by an independent healthcare professional working on behalf of the DWP. So they will really just sort of expand on the information provided in the form and just try to get a greater understanding of the difficulties that somebody experiences day to day. Off the back of that, a report would be forwarded to the DWP. DWP decision maker would use all the information provided. So the report from the independent medical professional, any evidence that's been provided by the claimant themselves, and then make a decision. And similar to DLA, decision notices would be posted out. And again, normal appeal rights will apply within the notice period. And PIP tends to be awarded for set periods, again, 2 to 3 years. There are no indefinite awards anymore, although those with sort of long-term health conditions that realistically won't see any improvement can receive PIP for 10 years. So carer's allowance. So carer's allowance is a benefit paid in acknowledgement that one has caring responsibilities for one who is severely disabled. So meaning someone's in receipt of a disability benefit like DLA or PIP on a regular and substantial basis. So the basic qualifying conditions are as follows. So somebody needs to be providing care for at least 35 hours a week for somebody in receipt of one of those disability benefits. There's no real definition of what care means. So care could mean providing physical care day to day with each of the activities that the disability claim convention looks at, or it could be speaking to somebody for perhaps 2 hours on a daily basis over the phone, making sure that they're okay. So care is very much open to interpretation. Don't have to be living with the person. So again, there's probably a misconception on that part. That someone needs to be living with someone. It's not the case at all. So carer's allowance is termed an income replacement benefit. So somebody can claim carer's allowance if they're working, but they would need to be earning less than 16 hours times the minimum wage, the national minimum wage, which is currently £196 per week. So if somebody was to earn below that, they would be potentially entitled to make a claim for carer's allowance. If they were to earn over that, there wouldn't be an entitlement. Yeah, similar to what we've discussed, basic conditions for carer's allowance. Earnings need to be below the threshold. There needs to be recourse to public funds, no immigration conditions attached to that. Need to have been present in the UK, which is the past presence test, similar to the disability-based benefits. Need to be in the UK and not in full-time education. So claiming carer's allowance, there's a really straightforward form online in order to do that. So carer's allowance can be backdated for a maximum of 3 months. So if somebody was to be awarded a claim, say for DLA now, because the claim would probably have started kind of retroactively from, say, for example, 6 months ago, you could potentially be entitled from the start of the claim. But if you were starting late, say there was a change in your personal circumstances, you could potentially look at claiming for that 3-month period, if that was to be the case. And the current rate of carer's allowance is £83.80 a week. So other entitlements that may sort of kind of ensue from a claim for carer's allowance. Anybody in receipt of carer's allowance will receive national insurance credits, which may be helpful towards future state pension entitlement. There's also an additional carer element in universal credit. So and there's an entitlement to this, whether somebody's working or not working. So it may sort of create an entitlement to some universal credit. So it may be some kind of good to look into that may apply or not. If you're claiming universal credit as a carer, there's the reduced claimant commitment. So you wouldn't sort of need to be looking for work or engaging with the job centre on a regular basis. There's, I don't really want to go into that, underlying entitlement to carer's allowance. So that really means that there may be some entitlement to some other benefits that you would be getting. Would you be receiving carer's allowance even though you're not? It's a bit complicated. I don't really want to go into that now. There may be a carer exemption in council tax that can reduce council tax by up to 25%. Can also cancel out any non-dependent deductions in universal credit. If somebody's renting over the age of 21, it can maximise your housing element entitlement. Carer's allowance is a taxable benefit. Just thought I would highlight that. And there isn't necessarily anybody, there's nothing restricting somebody making a claim for PIP, receiving PIP, and then claiming carer's allowance for somebody else. On the basis that the sort of care needs are very different to the restrictions that you're reporting yourself, if that makes sense. If there are similarities, that makes it perhaps a little bit more difficult. But if they are different, say one is more sort of prompting and encouraging more than sort of physical, that may be sort of workaround, if that makes sense. So I thought we'd touch briefly on appeal rights and how to go about doing that. So in terms of appeal rights, all WP benefit decisions are subject to appeal rights if you disagree with them. There is a two-stage process to this. The first stage would be to ask for a mandatory reconsideration. So this is in effect asking the decision maker to look at the decision again if you think that anything has been missed from the claim or omitted. There's normally a timeline of 1 month to request this, but this can be requested up to 13 months from the date of the original decision. And this again is another misconception, I think. A lot of the DWP award letters do state the appeal rights in terms of mandatory reconsideration, but limit that to 1 month. And I think that people are very sort of anxious about meeting that 1 month timeline. And it's not strictly true. It's highly unlikely that the DWP would refuse a mandatory reconsideration, at least the right to sort of look at it on the basis that it's late. It's highly unusual. So the 1 month time frame is not absolute in any way. So once a mandatory reconsideration has been completed, still not happy with the decision, the next stage would be to refer the matter to the independent tribunal. So the tribunal will look at all of the evidence again, look and see whether the decision was correct, and then make a fresh determination. Yeah, so there are kind of, I guess, and there's another sort of workaround that appeal rights are not time limited. So if there's an official error, there are sort of no time frames to that. So for example, if the DWP got the law wrong, I guess an example of that would be if you reported to the DWP that you were claiming that you had, say, 2 children, and they were only giving you the child element for 1 child, that's an error of law, and there's no time frame. So if you were to report that, even sort of 5 years down the line, the DWP would need to go back and backdate you for that period.